California. Latest decrees on working time. Recent case law on rounding of working hours according to the Fair Labor Standards Act. FLSA, recording of working time rules. Infrequent and insignificant periods of time beyond the scheduled working hours, which cannot as a practical matter be precisely. The courts have held that such periods of time are de minimis, insignificant. This rule applies only where there are uncertain and indefinite periods of time involved, a few seconds or minutes in duration, and where the failure to count such time is justified by industrial realities. California has adopted the FLSA timekeeping regulations for rounding hours worked, wherein the adopted standard allows an employer in California to round employee start and end times to the nearest 5 minutes, 1/10 of an hour or quarter of an hour, so that the time that is rounded averages OU. The California courts have taken varying viewpoints on this matter. In Candy Shops Incorporated v. Superior Court, 2012, it was held that an employer may implement a rounding policy if the rounding policy is fair and neutral on its face, and is used in a way that will not result in failure to compensate. Contrary to the above, in Donahue v. AMN Services, LLC, 2021, the California Supreme Court passed the long-awaited judgment wherein it was ruled that employers are required to follow strict compliance with California's meal break regulations and denounced the practice of rounding meal periods to T. To read more about Donahue v. AMN Services, LLC, please refer to our previous blog. Recently, on October 24, 2022, the California Court of Appeal in Camp v. Home Depot USA, Inc. passed another important judgment on rounding policies. The court ruled against rounding policies. Case highlights the plaintiffs, Delmer Camp and Adriana Correa, were hourly, non-exempt employees of Home Depot. E.g., 6 hours and 3 minutes are rounded down to 6 hours, 6 hours and 8 minutes are rounded up to 25 hours. A class action lawsuit was initiated against Home Depot on the basis that the company's policies led to underpaying its employees. Further, the decision of the trial court was appealed by the plaintiffs. The ruling of the trial court was overruled by the 6th District Court of Appeal. It held that if an employer has the ability to capture the exact amount of time worked by an employee, the employer is required to pay the employee for all time worked, down to the minute recorded. Even a fair and neutral rounding policy, which would have been considered a viable defense under prior appellate court decisions, may no longer be a defense for employers with electronic timekeeping systems, exposing employers to significant wage and hour liability. Takeaway: previously, many California courts held that the de minimis doctrine provided a defense against claims that an employer failed to pay for all hours worked when the amounts of time at issue were short, and there were practical administrative difficulties in recording the actual time worked by. The court concluded the de minimis doctrine was incompatible with California Labor Code and wage orders, which require payment for all time worked and generally confer broader rights to employees than the FLSA. The court also explained that it was reluctant to adopt the de minimis doctrine when technological advances enable employers to more efficiently track small amounts of regularly occurring work time. California courts are trending toward placing an absolute responsibility on employers to capture and pay for all work activities. Employers in California should therefore review all of their pay practices and policies to ensure they are in line with not only the law, but also the precedents of the courts. Boot up time compensable for call center workers. On October 24, 2022, the U.S. Court of Appeals for the Ninth Circuit, which covers California, Nevada, Arizona, Alaska, Hawaii, Idaho, Montana, Oregon, and Washington, as well as the U.S. territories of Guam and the Northern Mariana Islands, in Cadena, case highlights the Cadena case laid down the following facts. Workers are required to clock in and out using a computer-based timekeeping program, and they are not pre-assigned computer systems. The workers estimate that it can take up to 20 minutes before the computer would boot up, so they could clock in due to the age of the computer or whether the computer was off versus in sleep mode. Thanks for watching. Please subscribe.